Director of the National Association of Development Organizations, and just want to thank you for taking time today to join us on the second and final webinar in a two-part series about procurement as it relates to OMB's grants management guidelines. Last week, you received a copy of the presentation, and we made it through about half of the slides. This week, we'll go through the remaining slides. The slides were sent to you yesterday, along with the handouts, which we referenced during the webinar. Webinars, as you know, are being recorded. If you would like to receive the links to access them, please send an email to Lori Thompson after the webinar today, and she will get you that information. As the webinars will illustrate, these new rules are very broad and go beyond simple purchases of supplies and equipment, but also apply to contracting with service providers under federal guidelines like the Older Americans Act or the Workforce Innovation Opportunity Act. Our trainer today, many of you know, is Bob Lloyd. Bob is respected authority on policies and practices affecting the award, administration, oversight of federal grants, contracts, and subawards. He has over 40 years of experience in federal award implementation. Prior to launching his management consulting practice in 1982, he was executive director of Grants Management Advisory Service and held staff positions in two large federally funded organizations. He's been a consultant and trainer or advisor to award and audit units in 16 federal award-making departments and agencies, and to recipient and sub-recipient organizations and their professional advisors located in all 50 states, D.C., several U.S. territories, and 18 foreign countries. Before I turn the controls over to Bob, please note that you can ask questions by typing them into the box on the side of your computer screen. We'll ask Bob to respond to these questions at the end of the webinar. With that, I'll turn it over to Bob to take us through the webinar.
Okay, thanks very much, Joe. I appreciate that introduction, and it's good to be back with you and the NATO staff for our number 2 webinar in the series. We left off last week having covered several key topics, starting with OMB's approach toward the issuance of standards for various kinds of management requirements, procurement being one of them. And we spent some time with the critical distinctions that are being reinforced under the so-called super circular between subawards or sub-grants and contracts under grants, which of course are what the procurement requirements are expected to be followed under. I hope that everybody has picked up the importance of using correct terminology and that the proper selection of a lower tier relationship instrument is really a critical part of this. Now, we started off with looking at the procurement life cycle, the various events that take place in the life of a purchase, emphasizing recipient and sub-recipient responsibilities. We looked at the requirements for a code of conduct, and I can't emphasize enough how federal officials look very closely at that. And then we dealt with the various acceptable methods of purchasing that OMB has laid out as possibilities for recipients and subrecipients. Now, at the end of the session, we encourage participants to submit additional questions related to the coverage that we had in session number 1, and at least one of your colleagues took advantage of that. I'm going to follow up with that individual directly, however, because as you can well imagine, some of the questions that arose or would arise are fairly complex answers, and I don't want to take away from the session for others to deal with that, but I will be in touch with the individual who submitted that question, so fear not. Now, with that, let's move on to flesh out the details of the remaining steps in the procurement process. And if we pick up on slide number 15 of the deck, the discussion of the subject of acquisition planning. Now, one of the things I think is extremely important going forward is for development organizations to use the terminology that the feds use when they describe various kinds of activities in the procurement process. You won't see the words acquisition planning specifically in the uniform guidance in section 317 to 326, but underlying a variety of requirements that OMB has instituted there, I think you can conclude that what they're talking about is acquisition planning. So in the first step of decision to purchase, checking the budget of your award to make sure that there's sufficient funds is not something OMB says you need to do, but common sense would dictate that that's the case. Now, another feature that they introduce is the words avoid unnecessary and duplicative purchases. And a lot of people looking at that might say, well, duh, of course we're going to do that. But here's the thing. The federal government has found that there have been a number of recipients around the country who from time to time have looked at their grant budget and seen, for example, that there's a certain amount of money available to purchase supplies. Let's just say for purposes of discussion, it's $25,000. And they think that that means that they have to purchase $25,000 worth of supplies. Not that they have the authorization to do so, but they should attempt to save as much money as possible and perhaps use the savings to deal with cost escalation that might occur in other line items of their budget. So OMB, dumbing things down to the worst kind of behavior, mentions avoid unnecessary and duplicative purchasing. They also suggest that there be consideration given to alternatives to purchase. So even if you have authority to purchase under your federal award, looking into whether it makes more sense to lease something or to maybe luck out and receive third-party in-kind contributions, or look at the possibility of federal excess and surplus property as a way to fulfill some of the needs you may have in your grant. With respect to that last one on excess and surplus property, I'm sure most of you are well familiar with the catalog of federal domestic assistance. And the General Services Administration, which is the federal government's kind of housekeeping agency, has several different programs that relate to this, establishing eligibility for various kinds of educational, nonprofit, and governmental entities. So this is certainly worth looking into as a way to maybe obtain something without the need to spend a lot of money, or maybe not have to spend any money at all. Now, the other aspect of acquisition planning is to look at what the feds call the procurement element of your grant budget. And I've listed there on slide 15 the line items in the standard form 424A, which is the application for federal assistance budget, the things that are involved with purchasing. I mean, if you think about it, personnel and fringe benefits are the only other expenses that are normally listed here, and everything else is something you have to buy. So going through your procurement procedures and the methods we talked about on day one is what's expected. The other thing I think it's fair to emphasize here is that in some grant programs, if you mess up procurement, you've really messed up the grant, because most of the expenditures that are being made are in the categories that you see listed there on slide 15. Now, acquisition planning also involves, if we turn over to slide 16, managing the supply chain and deciding, for example, whether aggregating purchases, in other words, bundling them together to obtain economy of scale, or breaking them out in order, for example, to solicit involvement by small and disadvantaged businesses, is a step that needs to be addressed as well. Obviously, bundling may result in significant savings in terms of economies of scale, but it may also introduce other kinds of costs which have to be considered in the overall pricing of the activity. For example, stocking up on things, you may end up with a significant price differential, but then you've got to store the items. And so thinking about those sorts of things is something that, again, OMB gets preachy about. Conducting market research. Now, the rules don't use this terminology, but I urge you to do so, because conducting market research is finding out who's out there who can fulfill your needs. And doing that outside of the normal purchasing process makes a great deal of sense. This is where, for example, soliciting the marketplace for requests for qualifications or for requests of expressions of interest. This can be done all during the fiscal year without necessarily tying it to a particular purchase. And what that enables you to do is to create pre-established bidders lists and things of that nature, which may be very helpful in terms of then reaching out to the marketplace to obtain offers for goods and services that you need to buy. OMB encourages cooperative purchasing. And of course, this is not something that's new to a lot of regional councils and regional planning organizations like yourselves, because joint purchasing or purchasing on state contracts, things of that nature are matters that have gone on for a long time in regional organizations. Now, the point here is that while doing that, the organization that is responsible for the purchase is ultimately the one that is responsible for assuring that the process through which the purchase is made has been properly conducted in accordance with the federal rules. Doing cooperative purchasing, for example, by intergovernmental agreement, is not necessarily an authorization to conduct sole source purchasing. So this is something that, while encouraged, needs to be carefully pursued. The final terminology that OMB uses here, related to acquisition planning, ties back to what I said a few minutes ago about the decision to bundle or break out. They encourage what's called value engineering, which is to look at the life cycle of the purchase from a standpoint of initial acquisition, and then, for example, the potential maintenance costs and things of that nature, to see what is, over the life of the purchase, the cheapest and best method to accomplish that. Now, moving over to slide 17, obviously the federal government likes competition. And so the statement is made that competition should be pursued that is free and open and to the maximum extent practicable. Now, I like to refer to that as casting a wide net. And how you do that, given the current technology, is probably something that needs a little bit of creativity. My experience with a lot of governmental purchasing requirements, whether that's at the state level or even at the local level, is that competition in those contexts was mandated in a statute that says you have to publish a notice in a newspaper having general circulation. Well, we've all heard how well the newspapers are doing. And so that's probably a method that, while still statutorily required of some organizations, is not necessarily going to rattle the cage of a lot of potential offers. So using your organizational website, developing web offers lists, including pre-qualified organizations of the type I referred to earlier, using electronic media, and even signing on to something called Federal Biz Ops, or Fed Biz Ops, which is the federal government's portal for announcing federal contracts. Well, one of the procedures that's available under Fed Biz Ops is they allow recipients of federal grants to publish their notices in those documents. And I believe the threshold for allowing that is any purchase over $100,000. So that might be worth exploring as well. Now, in terms of casting a wide net, one of the things that's gotten a lot of attention is the affirmative steps that are contained in section 200-331, which require organizations that are purchasing with federal grant funds to take affirmative steps related to the types of enterprises that are identified in those sub-bullets: minority business enterprises, small businesses, women-owned businesses, and labor surplus area firms. Now, I would urge you to take a close look at that particular section of the rules, because even though they identify affirmative steps that must be taken, there's careful conditional language in each case, and it leaves a lot of judgment to the procuring organization as to how to fulfill that. But I can tell you from direct experience and recent experience that some of the federal inspectors general offices are looking very closely at whether organizations have created solicitations which encourage the involvement of these types of firms. So certainly be aware of that. Another issue that OMB addresses is the concept of geographic preference. And of course, a lot of governmental units, state governments, as well as units of local government, have in-state preference or in government preferences for firms that are located within their jurisdiction. What the federal government says is that those can't be used when you're spending federal funds. Obviously, the federal funds are coming from everybody nationwide, and so precluding an organization from competing because of where they're headquartered is problematic. Now, having the ability to perform in a particular location is different from being located there, and that's a distinction that you ought to keep in mind as well. Finally, in section 203.19 of the regulations, OMB lays out a number of impermissible restrictions on competition. And once again, there's some language, primarily adjectival language, that talks about whether or not that kind of step is something that restricts competition. An example of what I'm talking about is would be an assessment of whether a procuring organization introduces unreasonable restrictions in terms of the ability of organizations to compete for the contract. Something that might be, for example, establishing a very high threshold of capability when the nature of the actual contract wouldn't demand that kind of an arrangement. So this is another place where you need to closely look at the language to be careful that you're not running afoul of that particular section. Now, OMB spends some time on developing solicitations, and this is covered on on slide number 18. This is not to say that every purchase that you make under, for example, the micro purchase methodology that we talked about last week necessarily has to have a formal solicitation. But when you are out generating competition under the small purchase procedure or the competitive sealed bids or competitive negotiation approaches, it's expected that what you're doing is announcing to the marketplace what it is that you need. And OMB makes it clear that contractor involvement in the creation of the solicitation is something that precludes that contractor from competing for the contract. Thinking back to our discussion last week, if you have a sub-grant or sub-award, the likelihood is that the potential sub-grantee or sub-recipient has a role in writing the scope of work, saying this is what we want to do and we want your support financially in order to accomplish it. In this particular situation, it's expected that you as the procuring organization are going to write the solicitation, whether it's an invitation for bids or a request for proposals. And the components of that solicitation would involve the features that are identified on slide 18 and following. So describing the federal program involved, the procurement method that you're going to be using, and the contract type. Are you expecting to award a firm fixed price contract or a fixed unit price contract or some variation of a cost type contract, such as a cost plus a fixed fee? That's the kind of stuff that needs to be articulated for the parties that you are seeking offers from. This is where OMB also introduces the long-standing requirement that says you cannot enter into a cost plus percentage of cost or cost plus percentage of construction cost contract. There's a federal statute that precludes the feds from doing that, and that's also extended to recipient organizations. Something that's going to be of great interest to the contractors is what we know as contract financing. In other words, how is payment going to take place? And in contracts under grants, as distinct from sub-awards, the expectation is that payment will follow the accomplishment of objectives. So there's nothing in the rules that precludes you from advancing funds to a contractor, but the expectation is that you would, if you do that, that you would have significant retainage so that you can assure that the contractor performs in accordance with the terms and conditions of the award and that you get what you pay for. So setting up or identifying what the payment milestones might be or the amounts involved would certainly be part of the solicitation. One other thing that I should mention at this point is that your solicitation should also say to the marketplace that you reserve the right to reject all offers. And this gets to something that I almost chuckle about sometimes. I've seen any number of solicitations for goods or services issued by recipients in which the solicitation says the budget for this is X dollars. And it's no wonder that the offers they get are all X minus one. Everybody, the budget for this is $20,000. There are a lot of $19,900 offers. And so, don't tell the marketplace how much money you have, but reserve the right to reject all offers in case all the offers come in over what you've got available, and you can re-procure, based upon what the economic reality is. Now, moving on to slide number 19, let's talk a little bit more detail about the kinds of solicitations involved. And this gets us into some of the alphabet soup of procurement. So I would urge you again to, take some of these acronyms to heart in terms of your own purchasing manual. Invitation for bids, of course, are solicitations in which the selection is going to be made principally on price. And we use invitation for bids when we're buying stuff, supplies and equipment. So the specifications would identify the salient features of what's needed. And this is a place where OMB does say that an organization may use a brand name or equal solicitation so long as they identify the salient features of the item so that a competing organization would be able to offer their activity or their item. In addition to that, the expectation and invitation for bids is that the award would go to the lowest responsible contractor. So responsive means that they're meeting your specifications. Responsible means that they're capable of doing the work and they have a record of integrity, and we're going to get into that a little bit later, and that they offer the lowest price. Now, with requests for proposals, that's where you're generally using the methodology for procurement of services. And so the features that are going to go into an RFP include a statement of work. What are the tasks that the successful contractor is going to have to accomplish, and what are the deliverables? What are the outcomes that are expected? Now, sometimes the statement of work will be a process-oriented statement of work saying, this is what we want you to go through in creating the deliverables, or it's a completion statement of work which identifies the outcomes that are expected. So keep those distinctions in mind. The technical proposal instructions are the instructions to tell the prospective contractors how to package their responses so that you've got something once they've responded that can be compared one to another. Some of this may have to do with the nature of the size of the submission or the format or things of that nature, but the idea of the technical proposal instructions is to make it easy on you to make what's known as source selection. And source selection, of course, is going to be based upon technical evaluation criteria. What are the bases on which these procurement actions will be taken? Now, sometimes that's done as an arithmetic evaluation criteria. Other times it's done as adjectival. And the difference is in arithmetic, it's just what it says. You're using a scoring system with points for each feature of the technical evaluation criteria. Adjectival, on the other hand, identifies a pecking order or priority where you're saying the most important factor is this, the next most important factor is that, and so on. Now, it's also possible in this particular methodology to engage in what's known as two-step procurement. And in that type of arrangement, what happens is you solicit first offers based upon technical capability. So everybody who can do the job is asked to submit their qualifications and their technical proposal. And you review those proposals from a standpoint of deciding who can do the work and who can't. That's what's called creating the competitive range. And then you ask for those organizations in the competitive range to submit their BAFO, their best and final offer. And that's when price comes into play. Now, this is probably a methodology that is going to be used in somewhat technical areas of activity, but it also is an attempt to try to deal with the economics as well as the technical capability. So the optimum contractor gets selected. In that connection, there are some special rules for audit procurement contained in section 200-509 that relate to requests for proposals. But let me deal with that just a little bit later on in the presentation, because there are some specifics there that go beyond what's in the procurement sections. Now, moving on to slide number 20, source evaluation. What we're talking about here is the process by which you take all the offers and you look at them from the standpoint of the evaluation criteria, which presumably are going to include their responsiveness. In other words, they're being able to get the offer in the right time frame and components, the responsibility of the organization and the factors that can be taken into account, and the application of the evaluation criteria. Now, this is a place as well where so-called vetting comes into play. And I'm sure a lot of you have confronted in the past the excluded parties list system, which is now posted on sam.gov, sam.gov being the system for award management. Every contract that you award over $25,000 requires that you check the excluded parties list system to see if the organization you are intending to contract with or any of its principals are listed there. Now, the chances are pretty darn good they aren't going to be. But this is a place where if I had a flashing light to send in your direction, I'd be flashing the words audit alert, because auditors love this one. They love to check to see whether you checked the excluded parties list system, and if you didn't, they've got you with a non-compliance finding, and they may very well be able to assert you've got a weakness of internal control, and that helps them prove that they were there. So be careful of that one. Now, over on slide number 21, we have an additional aspect of source evaluation, and that's cost or price analysis. OMB says that cost or price analysis is required in all procurements by recipients that are above the simplified acquisition threshold. And you may remember from last week, the simplified acquisition threshold is an amount set by the federal government for its own purchasing. It's $150,000. So anytime you make a purchase of over 150 grand, you have to engage in cost or price analysis and document it. Now, this is a problematic provision in the rules. I don't think it's particularly applicable in the grantee community, but it's something the feds borrowed from their own practices as well. They say that you have to create an independent cost estimate prior to the solicitation. I would argue that your grant budget is where you created an independent cost estimate by estimating what you thought it was going to cost at the time you submitted the grant application. But that's another one where it makes sense to be able to point to something that says, this is where we got the idea as to what this should cost. Now, when it gets to cost or price analysis, it matters how the offer was solicited. In other words, if an overall fixed price arrangement was solicited, then what you're doing is comparing the offers of multiple potential contractors, one to another. On the other hand, if you required the offerer to break down their price into various cost elements, then you are expected to look at each of those cost elements from the perspective of necessity, reasonableness and benefit to the overall contract. So it's, documenting that you've done that is certainly part of the records that you're going to have to generate related to that purchase. If there's a breakdown of costs, there must be a separate negotiation of profit. And unfortunately, OMB did not provide any guidance about what is a reasonable profit under the circumstances. The other thing I want to mention here, and this goes to a comment I made in the initial session last week, there's nothing to preclude a governmental unit or a nonprofit organization from being a contractor under a grant and from earning a profit on that type of deal. Okay, I've run into some federal auditors who say, well, if it's a nonprofit organization, they can't earn a profit. Well, they don't know what they're talking about. A nonprofit organization can earn a profit. It's what they do with the profit that is restricted. So if you're dealing with a contract under a grant and the offer is a nonprofit organization and you've required them to break out their costs, then profit can be part of the equation. Now, if there's a cost breakdown, the uniform cost principles apply, and that's subpart E of this same document. Just to remind you, on the initial slide we gave you last week, and that you certainly have now, there's a link to www.ecfr.gov, which is the Electronic Code of Federal Regulations, where you can download the entire 2 CFR 200 or Super Circular, as you may choose to refer to it. And I would imagine that a lot of you have done that before. So this would be the cross-reference that you need to be make aware of. Now, source selection. What are we talking about? We're talking about the actual placement of a contract and contract award. A moment ago, I was talking about documentation. What you want to do here is you want to avoid what some of my colleagues in the audit community call black box purchasing. And what they mean by black box purchasing is that all the offers that came into the procuring organization come in one side of the black box. The successful contractor comes out the other side, and you can't tell what went on in the box. So being able to show how you made the selection. Let's say you had 5 offers from companies A, B, C, D, and E, and you chose company C. Your documentation needs to be able to show how you disposed of companies A, B, D, and E, and resulted in the selection of contractor C. Okay? Now, once that selection is made, you're expected to put in place a contract. You may call it a purchase order. It's a purchase instrument. And having a sound and complete agreement is critical. Now, here, OMB did not go into detail about what constitutes a sound and complete agreement. So the listed items that you see on slide 22, I guess I would say come from Business Law 101. In other words, if you took that kind of a course at some point, what they told you was that in order to have an enforceable contract, you've got to have an offer, acceptance, you've got to have legal content, there must be consideration in the form of payment, you must identify the jurisdiction in which issues might be settled, the obligations of both parties, the rights and remedies that both parties have, particularly in the case of breach of contract, and the fact that the contract has severability, so that if one part of the contract is determined to be null and void, it doesn't completely void the rest of the deal. Now, I'm not an attorney, but I think taking those elements and stringing them together in a common sense manner, and then perhaps showing it to your legal counsel is appropriate. And this is a particularly good time to do that, because a lot of you have got existing contract templates that need to be looked at and see whether they continue to align with the federal requirements. One of the ways that alignment needs to occur has to do with the required federal clauses, which are contained in Appendix Roman numeral 2 of 2 CFR 200. Now, let me warn you about something. The standard form 424B, the application for federal assistance, has what I'm sure many of you recognize as the Statement of Assurances, which lists a number of laws and executive orders and regulations that apply to federal financial assistance. Those requirements are going to flow through to a subrecipient. They do not flow through to a contractor. And so what OMB has done, and I think it's a favor for all of us, is they've listed in Appendix Roman numeral 2 the clauses that need to go into your contract because of federal law and regulation. And if you were to hold Appendix 2 up against the Statement of Assurances in Standard Form 424, you would find there's only a couple of things that are the same. Everything else is different. One thing that I've run into throughout my career is situations in which a lawyer for a grantee has taken everything that belongs in a subgrant, everything that belongs in a contract under a grant, mixed them together, called it by some other name, and sent it down to the lower tier. And that's been the thing that's caused so much confusion. Well, OMB, I think, has created a way forward to sort that out by doing what they've done. Now, once the contract's in place, it's important to get what you pay for. And so slide 23 addresses contract administration. But unfortunately, section 200.318B of the regulations is all of 2 sentences that tells you what to do. And it says basically to conduct oversight of contractors to see that they perform in accordance with their contracts and they comply with its terms and conditions. So how you do that is left very much to your devices. I think it's interesting that OMB tells you in 2 sentences how to do this, whereas it takes 132 pages of the federal acquisition regulation to tell themselves how to do it at their level. So here are some things to consider in terms of contract administration. Do you need to have access to the contractor and its records? In contracts that are cost type contracts or that are negotiated, that is a given. Whether or not you can go behind the counter with somebody who's selling you something on a fixed price basis is a whole other kettle of fish. And I would argue it really isn't necessary, although depending upon your assessment of the reliability of the contractor, you might try to negotiate that in. Another thing in terms of contract administration is avoid interfering with the contractor's performance. There is lots of common law cases that involve situations where the contractor didn't get paid and they in turn countersued and said they couldn't perform because the purchasing party was in the way. So, this is an arm's length transaction. You're expected to let the contractor perform and get the results that you've dictated among the deliverables. Now, what tools are available for contract administration? Well, let's turn over to slide number 24 for that, because there may be some slight differences in terms of the approach that's used. Contract administration arguably may be so commonsensical that we don't even think of it using that terminology. In the left-hand block on slide 24, when we're buying supplies and equipment, the first thing is to enforce delivery. The items were due to be delivered to your location at 3 p.m. Eastern Daylight Time on August 16th. They aren't there, enforce delivery. Once they are there, conduct inspection. Make sure that the numbers that were ordered are there, that the nature of the assets is whole, that there aren't any there's no breakage, things of that nature. And it is under those circumstances that the concept of acceptance comes into play. Now, obviously, once acceptance is occurring, then payment in accordance with the terms and conditions of the contract would be relevant. And the question of whether retainage under those circumstances should be introduced. That is, holding back a certain amount of the contract price until all matters are resolved is certainly something that, if it's going to be done, it needs to be alerted to the prospective contractor at the time the solicitation is made and at the time the contract is actually issued. Finally, enforcement of warranties. If there are warranties related to the supplies or equipment, then being able to enforce those and require replacement or refund or things of that nature is also considered to be contract administration. Now, you'll notice that the list of things that need to be done in services and construction doesn't depart from those common sense kinds of approaches, except we introduce the notion of oversight of the work process. And as I alluded to a moment ago, you want to avoid interfering with the contractor's ability to perform, but having the ability to oversee the work process through monitoring or other means is certainly something that would be appropriate for certain contracts to be undertaken. And again, alerting the contractor to the fact that you reserve the right to do that, both in the solicitation and in the written contract, is certainly appropriate. Now, slide 25 gets to the issue of procurement records. And I've alluded to documentation a little bit before, but this is covered in section 200-318I. And OMB says that you need records that provide for the significant history of the procurement. This is language that comes out of the old OMB circular A102, which applied to state, local, and tribal governments. So some of you may remember this terminology. But the thing to remember about the significant history is it goes back to the entire process that we've been talking about here, from the time that the decision is made to conduct a purchase through the decisions related to what methodology is going to be used, what type of contract, how the marketplace is solicited, and how competition is obtained, how the source selection process works, and the ultimate decision to place a contract with the successful contractor, and then to document that there's actually been delivery. So in a sense, I think the life cycle of a procurement almost creates the kind of checklist of information that you should be prepared to have in files related to purchases, particularly large ones that involve public solicitations such as competitive sealed bids or requests for proposals. Now, the rationale for the procurement method and the selection of contract type, how was that decided? How was that appropriate to the circumstances? How did you evaluate and select the successful contractor? Remembering our black box purchasing image. What's the basis for the contract price? Now, when competition is conducted, when competition occurs, this isn't hard to do. But obviously, if you are engaged in non-competitive negotiation or sole sourcing, then how you end up with these kinds of decisions related to a sole source involves somewhat more creativity. And I'm not using the term creativeness to imply that you're somehow playing fast and loose, but recognize that non-competitive negotiation or sole sourcing is management by exception. And this is something that in all likelihood is going to be closely scrutinized by your independent auditors or by federal officials who come in either on monitoring visits or, in the case of the inspectors general, in an audit of your organization. Now, essentially what all this boils down to is an audit trail from the beginning of the process of making the purchase. And again, that goes back to the importance of what form of purchasing you are engaged in. If your transactions are going to enable you to use the micro purchase threshold, a lot of what I've been talking about here becomes largely unnecessary. But once you move into the small purchase threshold, where you are expected to obtain offers from what OMB calls a reasonable number of sources, or you're engaged in invitation for bids or request for proposals, then the notion here is that you really do need to document the process that you've gone through so that somebody looking over those documents without verbal explanation from you can determine how this decision was made. Now, I said earlier I'd spend a little more time on the special rules for audit procurement, and this is on slide number 26. I would be remiss in not pointing out that there's a little bit of a conflict of interest here in terms of independent auditors. Independent auditors doing your single audit under subpart F of 2 CFR 200, which is the new nomenclature for the old circular A133. If they're doing that audit, you're expected to use the same procurement procedures that you are using to select providers of goods and other services that you are going to use related to the audit. And so it's, one might ask, is the independent auditor going to write you up for procurement violations when the same procedures were used to select them? That's a question I've heard asked by a number of federal officials who don't have a good answer but don't like the situation. They don't think it's a good idea to have grantees select their own auditors. Unfortunately, they're going to go to their retirement parties with that viewpoint because the federal government has essentially said that's the way we're going to do business ever since 1984. So that being said, there's a big federal concern about the quality of audits that are procured. And slide 26 addresses the special rules for that. What you're expected to do under section 200, 500 and following is to identify the objectives and scope of the audit. Now, a single audit done under these procedures is a multifaceted financial audit. The auditor is going to determine whether the financial statements of your organization and its schedule of expenditures of federal awards are accurate in all material respects, and is expected to issue an opinion letter related to that. Obviously, if they can say that your financial statements and your CFA are accurate, that's going to help a federal official sleep better at night. The auditor is also supposed to study and evaluate the internal controls over compliance with federal rules, essentially your grants management system. So in addition to looking at your accounting system, your property management, your subrecipient management and monitoring, they're going to be looking at your procurement procedures and seeing whether the features that I've been talking about here in the webinar are present and whether they are working. In other words, this is the way, not just that your manual says you do business, but this is the way you actually carry things out. Now, the audit procurement section 200-509 references something called GAGAS, Generally Accepted Government Auditing Standards. These are standards issued by the U.S. Government Accountability Office that establish how auditors in the federal government and how auditors who are relied on by the federal government will conduct their field work and reporting. So mentioning this acronym in the solicitation would be expected. Now, some of you may know GAGAS by another name, the Yellow Book. This is because back in 1972, when the first version of it came out, the title was very long, but it was a bright yellow cover. And so auditors began to refer to it as the Yellow Book, and GAO ever since, every time they brought out a new one, has published it with that color. So there's the history on that. You're required to request the peer review report of the auditor. The peer review report is a report done when the auditor's organization is reviewed by other auditors to see how they do business and how they conduct their practice. And it answers the question, who audits the auditors? So you have to ask for that as part of your procurement process, and the auditors are required to provide it, because the assumption is that that peer review report might identify any warts on that organization in terms of its practice related to audits. So, it's Some people look at this as a silver bullet related to audit quality. Now, unlike what has occurred in sections 317 to 326, where OMB does not go into detail about what evaluation criteria you would use in procuring services under an RFP kind of an arrangement, they go far beyond that in the audit procurement area. There are 5 factors that are specifically listed: responsiveness to the request for proposals, relevant experience of the organization, and of course this may reach back to their involvement with audits under Circular A133 or even as far back as OMB Circular A128. The availability of qualified staff. Now, qualified staff are established by identifying those who have had sufficient continuing professional education to keep up with the trends and issues in auditing federal assistance programs. Under the GAGAS requirements, auditors are required to take 80 hours of continuing professional education every 2 years. At least 20 of the hours must be in a particular year, so they can't load it all into the end of the second year. And at least 24 of the hours must be in topics directly related to government. So this is another place where, looking at the parties who would be identified to conduct your work would be a key factor. The results of peer reviews as well as quality control reviews. Now, quality control reviews are reviews conducted by the federal government of the working papers of an audit organization to determine whether the work that they did supports the conclusions that showed up in their audit report. Now, it's not likely that many non-federal audit firms have gone through a quality control review, but certainly asking whether that's occurred, and if it has, obtaining the results would be a factor to be considered. And finally, price. So price is a factor, but it may not be the controlling factor. OMB reminds everybody that positive efforts related to certain types of businesses must be conducted here, and identify the possibility of even subcontracting with such firms. And they carry forward a restriction related to indirect cost rate proposal development. They say that if an organization recovers more than $1 million annually in indirect costs, any audit firm that helped prepare the indirect cost allocation plan and rate proposal may not compete for the audit engagement. And obviously the concern is that they'd be auditing their own work. Now, let me shift gears a little bit and revisit some of the areas that we looked at early on the first day, because I think one of the main concerns that many RDOs will have going forward will continue to be differentiation between what goes on when you are subawarding federal funds to a subrecipient versus what you are doing when you are purchasing goods or services from a contractor. And so I want to talk a little bit about selection of subrecipients and contrast that to what we've talked about in terms of selection of contractors. So let's pick up on slide 27 for that purpose. Now, the ability on the part of a so-called pass-through entity, which is what you are when you're a prime grantee, to subaward is actually covered in the uniform guidance in section 308C1. Basically what it says is that if an organization wants to subaward, contract out, or otherwise transfer substantive activity to a third party, they must have awarding agency approval. Now, in some cases, in the programs that you administer, that federal awarding agency or pass-through entity approval is by design. Going back to the comments Joe made at the beginning, some of you who are administering the Older Americans Act and your organization is the Area Agency on Aging or houses the Area Agency on Aging, you know, that entity is a subrecipient. The State Unit on Aging provides the funds in the form of a subaward, and the area agency becomes the entity that is then deciding whether to subaward or contract out. But the notion is that unless there's some reason for that area agency to actually perform the services themselves, that they are going to be dealing with a third party consistent with the Older Americans Act regulations. Well, that's just one example of the kind of thing that, you know, almost by definition creates the ability to do that. But if that's not the case, then the grant agreement or sub-grant agreement needs to contemplate that subawarding of federal funds is acceptable. Now, let me emphasize this. The procurement requirements we have been going over in section 317 to 326 do not apply to selection of subrecipients by their terms. There are a number of federal agencies that I think are trying to get organizations to select their subrecipients using those procedures. But if OMB meant for that to be the case, they didn't do it in the way they organized the regulation, because everything to do with subrecipient management and monitoring is in sections 330 to 332, whereas everything to do with contracting or procurement is in 317 to 326, and they didn't mix the two together. So that's why, you know, in terms of creating a methodology for selecting subrecipients, I think absence any statutory requirements affecting your program, you've got a certain amount of flexibility in how you do that. But that being said, OMB also says you need effective internal controls that provide reasonable assurance you're complying with laws, regulations, and terms and conditions of awards. So having a procedure, perhaps where you are borrowing from some of the procurement requirements in 317 to 326, might be an appropriate response. But you know, the idea that you're required to do it, as opposed to it being a nice reference to use, I think is the distinction I want to emphasize here. Now, from there are several steps that are expected to be conducted vis-a-vis subrecipients. One of them is called risk assessment. This is covered in section 331B of the regulation. And you'll notice there on slide 27, it looks like I've reversed the order of things that OMB has presented. I think OMB had it backwards. I think you conduct risk assessment of potential subrecipients before you actually give them a subaward agreement. And arguably, you would create the subaward agreement based on the fact that you've determined whether there is sufficient risk or perhaps insufficient risk associated with that particular subrecipient. So the idea here is that, you know, you may still have to fund somebody because even though they present a high risk to you, but you would fashion the agreement with them to address those risks and not treat them the same way that you would treat an organization that goes through the risk assessment without any fault being found. This represents a concept in federal regulations known as differential accountability. You're not required to treat all of your subrecipients the same way. And if you need evidence of that, let me give you one other citation to reinforce it. And that is section 200-207 of the regulation, which is called special conditions. What it enables a pass-through entity to do, like yourselves, is to impose special conditions on a particular subrecipient who's got potential problems. You've got to fund them because there's a significant need for the funds, but their management is not particularly capable. They might be deemed the subrecipient from hell, but you've got to deal with them. Well, OMB gives you the tool to treat them differently from the subrecipients elsewhere in your portfolio who can handle management of their subawards in a much more judicious fashion. So that's why the sub-agreement provisions in Section 331A crosswalk over to that particular requirement. And as I've emphasized a couple of times, the sub-award agreement provisions in 331A are going to be different from the contract provisions that we referred to in Appendix Roman numeral 2 of the regulation. Now, let's dive a little deeper into those steps on slide 28. In conduct of the risk assessment, here are the factors that OMB says to take into account: prior experience with federal awards, the results of audits, which can include single audits as well as audits conducted by others, whether the organization has new personnel or systems. Now, the ability to manage is what's being assessed here, and the results of any monitoring that may have been occurring of this subrecipient by your organization or by others who are funding them. Those sorts of things are not expected to be closed up. It's entirely possible that you could inquire of other organizations who fund these subrecipients to find out what they've determined. One of the things I run into fairly frequently, and I'm sure you have as well, is that a lot of monitoring that takes place from the state level comes out and asks the same questions from different agencies. And, unfortunately, those state agencies aren't coordinating with one another, to avoid the necessity of going out and wasting everybody's time with the same inquiries. Well, that's something we won't solve today, but I simply point it out because I think OMB contemplates the possibility that that sort of rational use of resources would be appropriate. The subaward agreement itself. Now, here's a place where the distinction between subawards and contracts under grants gets reinforced. OMB says that if you're making a subrecipient award, a subaward, that you have to identify it as such, that this is a subaward of federal financial assistance. In fact, that's when I've talked to my clients about writing a subaward agreement, I think that's the first line of the agreement, because then after that, you've identified what your purpose is, what your intent is. And you may even supplement that by saying it's not a purchase of goods or services. The required data elements, OMB has given you a template for what belongs there. You identify as well the flow through of the primary award requirements. This is where you would reference the entire 2 CFR 200 as being something that the subrecipient would be expected to adhere to. Why? Because the federal assistance funds have not lost their identity. Any supplemental requirements that are added by the pass-through entity. Now, this is not OMB saying that it's okay to load up a subaward with everything but the kitchen sink, but they recognize that there are some things that may need to be there in order for the pass-through entity to fulfill its obligations back to the federal government. And this is where, as well, the special conditions for high risk would come into play. The final item is the indirect cost rate recognition. If a subaward is being made, then the negotiated indirect cost rate agreement that applies to the subrecipient is something that the pass-through entity must recognize. OMB gives no exceptions there. But if the subrecipient does not have a negotiated agreement, in all likelihood because they don't have a direct relationship with the federal government, then OMB lays out two options. One is the negotiation of a rate with the pass-through entity, which would apply only to the pass-through award, or the election of what's known as the de minimis indirect cost rate, which is defined in the regulations as 10% of the modified total direct costs that are charged in an award during a performance period. Now, we could probably deal with a whole webinar just on that subject, but suffice it to say that that's where the requirement comes from in Section 331A. Now, let me wrap up by identifying what I think are some key takeaways on procurement. First, this goes back to something I warned you about early on the first day. On May 17th of this year, OMB put in the Federal Register an announcement that indicated that they had granted an additional 1-year grace period for non-federal organizations to implement the procurement procedures of 317 to 326. Now, that additional year was tacked onto 2 previous years of grace period. So essentially what OMB was saying was, if your organization makes a decision to do so and documents that decision, it would not be required to fully implement the procurement procedures until the end of the 3rd fiscal year after the effective date of the uniform guidance. The effective date of the uniform guidance, to remind you, was December 26, 2014. So for example, for an RDO that has a fiscal year that began or begins on July 1st, the July 1st, 2015 to June 30, 2016 fiscal year would be the first one that the grace period was applicable to. The fiscal year that began July 1st and ended July 1st, 2016 and ended this June 30th would be the second year. And the fiscal year that began July 1st, 2017 and ends June 30th, 2018 would be the final fiscal year in which this was possible. Okay. Now, if you haven't already made that election, you need to do so so that your independent auditors can see that that has happened. Okay. But I guess my suggestion here is that given what we've talked about in these two webinars, getting with the program is something that eventually is going to have to happen anyway. So I think right now is a ripe time to review the policies and procedures your organization has for entering into lower tier relationships and realign those as necessary. What I think you need is 2 packages. One that says procurement of goods and services in big letters, and the other which says subaward of federal financial assistance. And then follow from those titles into the procedures that we've talked about here. A companion step is to review and revise existing agreement templates. I'm sure that many of your organizations have standard, what you've called contracts for years, and probably some of them are the kind of hybrids that I referred to earlier, a mixture of grant features and contract features. Now is a good time to take those things out and look at them compared to the language that is contained in the sections I've cited, and to get out your pruning shears and take things out that don't belong there, and perhaps, add in some things that haven't been there in the past that belong, so that you've got 2 separate and distinct legal instruments that you can use properly going forward. And I know, for example, particularly larger organizations may have a whole family of these agreements. Last week, before the first webinar, I had an engagement with a university, a very large university that has a lot of federal awards. And they issued a contract to me that was very clearly fashioned based upon the relative size of the contract, but also kicking in certain procedures that were appropriate based upon the rules that we've talked about here. So they had already kind of gotten with the program. I think you should recognize your vulnerabilities. Whenever there's a big change in policy, certainly federal agency and pass-through entity monitoring, checking to see whether certain features are present and whether they're being followed is the common practice. And even though some of that monitoring might arguably be duplicative of what is going to go on under a single audit, I think you can expect it to happen and not be in much of a position to resist it. So again, getting with the program and having a good defensible set of policies and procedures that's actually being followed is the answer. if you're dealing with your independent auditors, the single audits under what is now called Subpart F of 2 CFR 200, the answer sheet for procurement is contained in OMB's 2017 compliance supplement, which is an audit guide that OMB brings out on an annual basis. Some of you may be familiar with it, or at least the fact that it comes out annually. But Part 3 contains audit objectives and suggested audit procedures for 12 different areas of federal grant compliance. One of those is procurement and suspension and debarment. So I think it's fair to say that the steps that the auditors are going to be going through are going to align very much with some of the things we've talked about here. And finally, don't forget about the federal government's audit capability. One place where this has been manifested very aggressively and recently is in the Department of Homeland Security Office of Inspector General's office. And of course, what they're auditing in many cases is grants that were made for disaster relief by FEMA or grants that were made for hazard mitigation by FEMA. Last year, so actually September 2nd of 2016, the DHS Inspector General published an audit report that was a broadside related to grantee procurement. You can look that up on Department of Homeland Security's website or get to it through the website of the entire Inspector General community, which is ignet.gov. But that's the sort of thing that I would recommend reading to reinforce your knowledge about the procurement requirements we're talking about. It's almost a fire bell in the night of this is the kind of stuff we and our colleagues in the IG community are going to be looking at if we come to visit you. So the answer sheets are out there, the compliance supplement and documents like I've just referred to. Recognize that this is a very important area with a lot of change associated with it. And, you know, I think hopefully with what we've covered in these last 2 sessions, you're at least well armed to go forward and create a defensible system for your own organization. So with that, let me turn it back over to Joe and to Laurie, and we'll open it up for the questions that you've submitted and hopefully some reasonable answers.
Sure. Okay, thank you, Bob. I appreciate that. It's a lot of information that you provided today. Again, we did have a few questions, and I just want to remind folks that if you have questions that you haven't posted, please go ahead and insert them in the box on your screen, and we'll get to them while we're on the call. So, Bob, the first one is, can you extend a current contract for services under a federal grant and still be in compliance with procurement standards?
Sure. There's nothing in the rules anywhere that identifies the length that a contract can be put in place for. Obviously, if a contract is put in place for an extended period, that takes away the argument that they've engaged in competition to the maximum extent practical. But here's the way that I think it makes sense to handle this. If you award a contract and you've placed it with a successful contractor and there's proper administration and performance of the contract, having an option in the contract for extension of time, in other words, to say that you as the purchaser may exercise an option to extend the contract for a subsequent period, that is the way that incrementally you would maintain control over the situation. So if, for example, you place a contract for year 1 and there are problems in terms of performance, you simply don't exercise your option and then you go out into the marketplace and re-procure. On the other hand, if year 1 performance is acceptable, you exercise the option and you don't have to go back out for re-procurement. Now, this is something that has particularly come up in the audit arena because, as I'm sure many of you are aware, independent auditors are reluctant to propose on contracts that are relatively short. And so it's common for RDOs and other governmental entities to, procure audit services for, say, a 3-year contract or a 5-year contract or something like that. And again, using the option approach, doing so gives the procuring organization control over the situation. So if there's a failure on the part of the auditor to produce, or substandard work occurs, they could handle it. I would use that kind of concept in the case that the questioner raised, perhaps for other services or goods.
Okay, we had another question. Is a code of conduct similar to a conflict of interest policy? Is there a standard format that you'd recommend?
Well, the code of conduct is really an overarching term, and conflict of interest is a subject within the code of conduct. At least that's the way the uniform guidance lays it out. It says you need to have a code of conduct, and in that code of conduct, you need to address conflict of interest and solicitation or acceptance of gratuities. The fact that OMB only addresses those two things doesn't mean that a code of conduct wouldn't, address other kinds of behavior on the part of employees, agents, or officers of the organization. But, in a sense, what OMB has laid out in Section 318 of the regs is the minimum that needs to be in your code of conduct. I'm sure that if you look at your personnel manual or your human resources policies, there probably are some issues there that, could become sub-chapters of a broader document called a code of conduct.
Okay, here's another question. If a specific company is mentioned in the scope of work in the federal grant application, are we exempt from the procurement standards?
That is one thing that is contemplated in Section 320F of the rules, in the section known as non-competitive negotiation. If you submit a grant application or sub-grant application and you specifically identify a company and the awarding agency approves your application, in other words, doesn't take that out, then essentially what you've done is submit a written request to the awarding agency to sole source. And that would exempt you from the procurement requirements. Okay, I think if I'm doing that, if I were in your shoes, what I would do is to effectively label that in the submission of the application, such as to say, in accordance with Section 200 320F, and then the subsection within that, I don't recall exactly which one it is. I think it may be the third one in the list, but in any case, get the right citation and say, in accordance with this, we expect to contract with ABC company, and then go on to describe why contracting with ABC company is critical to the programmatic purposes of your award. In other words, just putting it in there isn't necessarily going to carry the day. You're still going to have to come up with a justification to do that. But that my sense is that with a reasonable justification, most awarding agencies are not going to complain. And another thing to keep in mind here, many of you are located in areas where getting contractors to compete for your work is difficult. Certainly in procuring service providers under some of the programs we've talked about that are very mature programs, there are not a lot of organizations pressing their nose to the glass wanting to get in and do work under those programs. So when you go out into the marketplace and solicit, you got the usual suspects coming back to you saying, this is our offer. That sort of situation is something that perhaps lends itself to a sole source justification to say, you know, we've procured in this marketplace for many years. Here is an organization that has significant capability and experience with this program, and accordingly, we believe it's appropriate to sole source to them. Now, when you do sole source, assuming you get the permission to do it, then conducting aggressive cost and price analysis so that you're making sure that they're not hosing you down is also something that is a best practice.
Okay, following up on that, may the engineering firm who develops the PER for purposes of a grant application compete during the RFP process for engineering design?
I think that would be, I mean, if I'm putting myself in the shoes of a federal official, I think that is something that would not be acceptable, because they had a significant role in preparing the scope of activity.
Okay, and here was our final question. Is procurement of single audit required regardless of costs? Also, if single audit costs are indirect, is procurement still required?
Let's take the second one first. The answer is yes. If your if your procurement of single audits is the charges are loaded into your indirect cost rate, then you are expected to conduct procurement under Section 200-509. Now, the first part of it was, can you go back over that part? I'm sorry, I had a senior moment.
Sure. That's okay. Is procurement of single audit requirement regardless of cost?
Yes. I mean, the fact that price can be used as a criterion for selecting the successful auditor is clear from the rules, but the issue of single audits, of course, is under the new rules, your organization has to expend $750,000 of federal funds from all sources in order to have to do a single audit at all. So, I'm assuming that most RDOs, have multiple program expenditures that take them over the $750,000 threshold. Well, once that happens, then going out into the marketplace and soliciting audit firms to do the work, price can be a factor in the selection of those firms. The example that I gave of two-step procurement under the discussion of solicitation, that might be precisely the kind of way that you want to introduce price. In other words, go out to the marketplace and say, audit firms, we have to do a single audit. Here are the parameters for doing that work. Please submit your qualifications. And then use those qualifications for deciding who is or which firms are likely to be capable of doing the work, and then solicit from all of them their best price to do the work for the duration of the contract. And then you've introduced cost into the decision-making process.
Okay, we just got another question. Can engineering for the PER and design be procured prior to grant application submission?
There's nothing in the rules that says when the procurement might take place relative to the use of a firm. It may very well be that an organization procures services from an entity and then has those services available when the grant application is approved and you are proceeding to conduct the work under the award. But again, if that successful firm is used, it's expected that they would have been procured competitively at the time that the procurement took place. In other words, you can't escape the competitiveness matter by doing it ahead of time.
Okay, well, Bob, that looks like it was the last question that we had. So,
do you want to also, I mean, again, I know we've dumped a lot of information on everybody here, and apropos of our previous invitation, I'd say, I think the last slide has got some contact information on it that if, you didn't get a chance to ask your question or something else comes up that you want a reinforcement on, get in touch and just say you were in the NATO procurement webinar, and I'll be glad to try to get back to you.
Okay, so everybody should have that information. You've got a copy of his slides. As a reminder, we did record both webinars, and we will be sending those out, the links to those out to everybody who attended both webinars at some point later this week or early next week, so you can have those on hand for reference. And I just want to thank Bob once again for sharing his expertise and knowledge with us. And a reminder to everyone, feel free to submit any questions that you didn't get answered today to him. So having said that, I think we're done and we can complete the webinar. Thank you, everybody. Nice comment.